skills and strategies for fighting for much needed change. The skills we'll discuss today are messaging and communications, creatively applying existing laws in novel contexts, using collective organizing tools, and utilizing state courts and state constitutional amendment processes. I'm excited to introduce you to your panelists today. First, we have Leticia Rojas, Director of Communications for the Texas Civil Rights Project. Shefali Desai, Associate Clinical Professor of Law, Director of the Workers' Rights Clinic, and co-chair of the Bacon Immigration Law and Policy Program at U of A James Rogers College of Law, and Teresa Woody, Litigation Director. Please hold questions till the end. Leticia.
So at the Texas Civil Rights Project, we like to say that we fight for change both in and out of the courts. So I would say communications is one of our strongest out of the courts tools. So what I hope you get out of today is an understanding of how you can use communication in tandem with any legal strategy. I'll go over some background on the Texas Civil Rights Project and give you two concrete examples from our work where we've used communications to advance our goals. Some background on the Texas Civil Rights Project. We started out in 1990 in South Texas, and now we are 40 people strong across the state. We are a mixture of lawyers, advocates, and community partners. Our partnerships with grassroots organizations is a key part of our work. And we work across 3 different issue areas. Our Beyond Borders work is focused on immigration and border communities. Criminal injustice work focused on reducing the harms of the criminal legal system, and our voting rights work. So my first example, I'm calling Biden's border wall. Some background on our border wall work. We had, for several years, been working on opposition to the border wall, and this came as a mixture of know your rights presentations, going to community meetings in opposition to the border wall, and public service announcements. And this all culminated in direct representation of several families in eminent domain proceedings. The case I'm talking about today is the Cavazos family. Again, we had been representing them for several years, but at this particular moment in time that I'm zooming into is April 2021. So we had been fighting with, until that point, the Trump administration. And then we had the Biden administration come in. We thought we would get quick and swift resolution through the courts, and that did not happen. Since in April, the Biden DOJ seized our client's land. And so at that point, we decided to go hard on the comms side. So what was our strategy? We targeted the Biden administration publicly. We went for DC-based publications and used very direct language. We also centered client stories in our messaging. You know, Texas legal nonprofit versus Department of Justice did not make for as good of a story as our clients, who were actually fairly elderly, but came out very forcefully in the media, was a lot more David versus Goliath. And we used multiple media platforms. So we were on social media, we had videos, we had press. We really tried anything and everything to get this story out there. And it worked. And we know not just because we got great reception on social media and these hits in places like the Washington Post and Politico, but our lawyers actually got some very angry calls from people in the administration. So we know we touched a nerve. But that was the point, you know. We thought we were going to get a resolution and we weren't getting anywhere. We had to find a way to force them back to the table. And in December of 2021, our clients had their land revested to them, as did several others. So why did this work? One was we put pressure on those public-facing decision makers. You know, Biden had just come into office campaigning on changing a lot of what the Trump administration did, particularly on immigration. So holding their feet to the fire was really important. Next, we built a base of support. You know, we had been in these communities in South Texas for a long time. And a lot of them organized against the border wall as a symbol. So we were able to make this case about more than just this one plot of land, but about the bigger issue of the border wall. And lastly, we raised awareness. So this was one of, again, many cases. And in fact, the Biden administration was touting that they had closed a lot of their cases. But because they were proceeding with this one and several others, we made sure that it didn't get swept under the rug. Some of the challenges were maintaining media interest over time. As I note, this was a case that lasted several years, and often the press wants to report on when there's a big development. So we had to get creative and find new media outlets, again, try on social media to make sure that we kept the pressure on. And lastly, this was a pretty tough negotiation. And once you go hard out in public, it made for some tense discussions on the litigation side. So for my next example, I'll go over something from our voting rights work. And I know I'm going over this quickly, so if you have any questions, feel free to find me afterward. Some background on our voting rights program. It's a combination of some direct service. We run the Texas Election Protection Hotline. This is, of course, a national hotline run by the Lawyers Committee on Civil Rights. We are the Texas leads, so we help voters through legal issues as they navigate their way to the polls. Second is impact litigation on major voting rights issues in Texas. And lastly, and what this case will focus on, is advocacy at the state and local level, particularly around the legislature. So in 2021, the governor of Texas decided that he wanted to go hard on voting, partly because of the strong narrative around quote unquote election security. He was like, oh, we need new restrictions in Texas. And what was proposed was a package of a huge set of restrictions packaged in an omnibus bill that was a must pass for the governor. So we knew we were facing difficult political odds, but we were trying alongside several partners to get at least some of the very worst restrictions in this bill out. These are some of the restrictions that were in the very first version of this bill as it came out. So restricting voting hours, including on Sundays in such a way that it impacted souls to the polls, requesting documentation of a disability to use vote by mail, and allowing partisan poll watchers to record video inside polling locations, among many, many others. This was a huge bill. So our strategy here was, one, to use the Capitol. It's not always easy, especially at the state level, to get a lot of coverage on voting rights as an issue. But the advantage of having this fight at the Capitol is that the Capitol does have usually a dedicated base of reporters that we could lean into. Second was centering our messaging around the worst parts of the bill. As I said, we were facing fairly difficult odds politically. We knew this was more than likely going to pass. So our strategy was to talk about the specific provisions that we knew would be the worst. And lastly, we used partners to amplify these key messages and made sure we were all saying the same things about the bill. And some of the tactics that this came out to was holding several rallies at the Capitol to garner attention. Also sign-on letters. So for people who wouldn't traditionally go to the Capitol or weren't around the area of Austin, we had sign-on letters showing, hundreds of groups opposing this bill. This included groups that don't usually get involved in this. So like chambers of commerce, we got to sign on to these. And this allowed us also to tailor our approach and have more people speaking out. And lastly, a lot of resources. So once some group came to us and they're like, hey, how can I get involved? We would start sharing these resources, these bill analyses and talking points so that everyone knew, not just like, okay, this bill is bad, but this is exactly why, and this is what you should be saying about it. And so we were able to get some of the worst parts of the bill out. Notably, the recording provision was taken out. The documentation of the need for documentation of your disability to use vote by mail was taken out. And we got an extension on voting hours. Of course, some of these terrible provisions still stayed in. So naturally, we sued because we are still a legal nonprofit. And as I said, communications is just one tool, and we use it with the legal part to advance our goals. So on this case, what was effective about it? I think on the first part, voting rights is not a hard sell. As I said, we work on several other issues. Many of them are a lot harder to get different groups on board. The chambers of commerce will never get on board with some of our criminal and justice programs work. But we use that to our advantage. We brought in all these non-traditional groups. And two, we had a clearly visible target. And we used the Capitol as a place that we knew had media attention, and we leveraged that to our advantage. And lastly, we have those strong partnerships. So TCRP works with a lot of other groups. You might have heard before, like Common Cause, League of Women Voters. And so we brought in those partnerships to fight this bill. Some of the challenges, I think, especially on the communication front, was fighting misinformation. The Republicans' framing of this was very much on quote unquote election security. I think their tagline for this bill was, it makes it easy to vote, harder to cheat. And so we were up at a disadvantage when it came to talking about why this bill was bad and why security was a misnomer for what they were doing. And then again, the difficult political environment. The numbers were against us. This bill was going to pass. So we tailored our strategy to harm reduction, since we knew we couldn't kill the bill completely. Some takeaways just overall on using comms. I think the first one is to have a plan. When it comes to communications, there's so many different tacks you could take. You could try to go to the press. You could use a digital strategy. You could do a combination of advocacy and communications where you're bringing people in to do something. So try to think about what your advocacy goal is and then tailor your communication strategy to do that. Second is, you heard me talk about partnerships a lot. So comms is a group activity. If it was just Texas Civil Rights Project opposes this bill, it is not as strong as, these chambers of commerce oppose this bill. It's a lot stronger when you have more people saying the same thing and rallying to your cause. And just as a plug for Texas Civil Rights Project and the work we do more broadly, these partnerships run really deep and help inform our legal work as well. Third, as a nod to the name of our panel, is to stay creative. The media and digital landscape is changing constantly. So you really have to be open to trying new things in order to move forward. And lastly, be persistent. Just like the work inside the courts, the work outside the courts also takes time, patience, trying many, many times. So please stay in touch. The Texas Civil Rights Project has legal fellows. We host summer law clerks. So we'd love to have you all around.
Hi, everyone. Thank you so much for being here on a Saturday. It's great to be here with you. So I'm going to talk really at the point where Secretary of State Fontes left off, and I didn't know he was going to leave off there, so that was really helpful. He left you all by imploring you not to lose hope, that is key to transforming our systems and structures and upholding the rule of law. So what I'm going to talk with you about is lawyering as an act of radical hope. And I did not come up with this term radical hope. Actually, this concept of radical hope, which I'm going to talk about throughout my time with you, comes from Chief Plenty Coups, who is the last great chief of the Crow Nation. And he talked about radical hope as a way to continue after complete devastation of his people. And if you're more interested in that topic, look up Jonathan Lear's book, Radical Hope. But I'm going to talk about radical hope lawyering. And you'll hear what that means as I go on, but I want to start with telling you what it does not mean. Because many of us think of hope as a passive thing. I will sit on my hands and hope that things get better. I will hope that the right thing happens. But that is not what I am talking about when I'm talking about radical hope. Radical hope is active, and it is an openness to imagining a way that as you sit here right now, you cannot conceive of. That all of your law school experiences and teachings and readings have not prepared you for. They've given you a bunch of tools, but they have not allowed you to imagine something that you cannot even conceive of right now. And so I'm going to give you a concrete example of what that might look like by telling you the story of the Workers' Rights Clinic, which I direct at the University of Arizona College of Law. So the Workers' Rights Clinic was created over a decade ago with the express purpose of serving low-wage immigrant and migrant workers across the entire state of Arizona. And to this day, I'm sad to inform you of this, our clinic is the only free wage and hour clinic in the entire state. That means that we help people from Cochise County and Flagstaff in the north of the state to Yuma, which borders California, to, of course, Maricopa and Pima counties, Phoenix and Tucson, and also rural counties like Cochise County and Santa Cruz County that have a southern border with Mexico. And we represent America's frontline and essential workers, the workers who are in the most labor-intensive, dangerous, and low-wage industries, construction, hospitality, cleaning, long-term care, all industries, by the way, that have massive labor shortages right now. These are the folks that keep this country running before the pandemic, during the pandemic, after the pandemic. And they are among the most vulnerable and marginalized communities. So the clinic was set up to serve those communities, and it was set up to do so in two primary ways. One was through education, outreach, and know your rights within the community, within these various communities. And the other, of course, was direct individual representation. And I'm going to talk to you about how radical hope occurred in both of those arenas, and continues to occur with the work of the clinic. So the first piece I want to tell you about is the education and know your rights piece, because I think that's not something we think about when we're law students in law school. But when you are a lawyer, or when you're engaging in any type of lawyering, you are an educator. I say to my students all the time, the best lawyers are also really good teachers, because you need to be able to communicate all of these wonderful, fancy, complex concepts that you spent 3 years in law school learning to people who have no concept of them. And in our situation, our clients often come from completely different structures, right? They're from, many of them, most of them, from different countries. They don't even, there are language barriers, but there are also concept barriers. And providing that type of information distilled in a manner that is calculated to provide comprehension to people who might look and act and live very differently than you is in and of itself an act of radical hope. And I'll explain in a little bit exactly what that looks like, but it is an incredible empowerment to people when you give them those tools and when you provide them with that language. So what do we do in our outreach presentations? So we, of course, tell them about the state laws that exist in Arizona, and our minimum wage and paid sick leave law is in and of itself an example of radical hope. It was a law that was placed on the ballot through voter initiative in 2016. And there were many groups that came together to get that done, including the clinic. And people said, this kind of a law will never get on the ballot in Arizona. It got on the ballot. And then people said, this kind of law will never pass in Arizona. And then it passed. And Arizona is one of about 30 states and localities that has a minimum wage that is absolutely essential, given that the federal minimum wage has not changed since 2009 and is $7.25. No one can live on that wage. And the other thing we did is we passed alongside that minimum wage law an earned paid sick time law, which, boy, now we can all see post-pandemic why that law was so crucial for workers during that time. And then, of course, we say that when we make our presentation, we want people to see that that kind of change is possible when people come together and work in a concerted way, because that is radical hope. And it gives people an idea that maybe they could do something like that because, and we talk about this very intentionally, those laws are still not good enough. They're better than what we had before, which was nothing, but they are not great. And of course, we talk about federal laws. We talk about the right to overtime under the Federal Labor Standards Act. We talk about the right to unionizing and collective activity and getting together with your coworkers to demand better workplace situations under the National Labor Relations Act. And we talk about the right of workers to safety and health in their workplaces under the Occupational Safety and Health Act. But we also talk about how, again, each and every one of those laws falls far short of what workers deserve and need. And in doing that, we are planting seeds of radical hope with our communities, because we're telling them, don't feel that you have to be okay with the law as it is, because the law is flawed. Even the laws that are helpful are flawed, and they are a floor, they are not a ceiling. So that's that part of our work, doing outreach presentations. Okay, what's the other part? The other part of the work that we do is, of course, direct representation of our client communities. And I'm going to tell you two stories here to illustrate what this work looks like, even when you have laws and rights that you can pursue. I'm going to tell you the story of Selma, not her real name. She was a long-term care aide for many years, over 15 years. Now, Selma is also a lawyer. She had a law degree from Mexico. But when she came here, she didn't have a choice. She had to do the jobs that she could do. And that was long-term care. And she said to me once, I'll never forget it. She said, I wish I could take care of my parents back in Mexico. That's what I want to be doing. But I can't, because I'm over here. So I'm going to take care of all of your parents, because you in America don't do that. I thought that was kind of funny, but also sad at the same time. But what I'm trying to say is she took this work seriously, even though it was not the work that she wanted to be doing. And she did it well. And she raised her children also while she was doing it. And she worked 70, 80, 90 hours a week with no overtime. Often she wasn't paid the minimum wage. And she never received paid sick leave. And every once in a while, she would say to her employer, she would say, because she had a law degree from Mexico, she knew she had some rights. And she would say, wait, isn't this something that I should be able to have? Shouldn't I get more money? And the employer's response, which is the response we see across the board with the employers we deal with, is, you are ungrateful. You should be grateful that you even have a job. You should be grateful that you're even getting what I'm giving you. And that quickly followed up by threats and intimidation, which is also ubiquitous in this area, implied and express. The threat that if you're going to keep bringing this up, you're going to be terminated, which people like Selma cannot afford, right? They have to have these jobs to put food on the table. And then the bigger specter of immigration enforcement, which some people like Selma's boss said explicitly, I can just call ICE. I can just do that instead if that's what you want to, talk about. And I want to say that it's not apparent. It was Selma knew, but it's not apparent to most of our worker communities that they actually have rights under employment and labor laws. And the reason for that, the big reason for that, is that employers say to them, you don't have any rights because you're not a US citizen, or you don't have work authorization documents, or just you don't have rights. And that narrative, fighting against that narrative, which we do on a client by client basis, is also an act of radical hope. And we say to people, it's absolutely essential that everybody has those same rights, because otherwise the law would be used to create a second-class worker who could be exploited by unscrupulous employers. And in addition to that, it would have the perverse incentive, it would provide a perverse incentive for employers to actually hire undocumented people, because then they wouldn't have to provide them with rights and they can turn a larger profit by doing that. So anyway, we agreed to provide legal representation to Selma. We helped her to identify her claims. We, with her permission, sent a letter to her employer saying, this is all of the wage theft that you've engaged in, and this is what you owe her. And the response of the employer, again, par for the course, complete and total outrage and indignation that she dared to speak up and use her voice. And so then we filed a lawsuit. And that lawsuit was filed in spring of 2020, 3 years ago. And what ensued was also what we see with our employers, which is delay, delay, delay. We need more time to file the answer. Okay, we'll give you this professional courtesy, we'll give you more time. No answer. This goes on for almost a year. We finally file a motion for default judgment in federal court. We get the default judgment, still no answer from the defendant. And then after the default judgment, the employer decides to appeal to the Ninth Circuit Court of Appeals, because now all of a sudden they want to be involved. But remember, it's on the default judgment. So what that means is if our client loses on the appeal, she gets to start all over again. She gets to come right back to the very first line and start all over again in the trial court. Even if she wins, what she has is a piece of paper. She has a judgment. And there's this concept when you come out of law school that that's the end when you get that judgment from the court, but it's not, it's just the beginning. Because now, if that is the outcome, which I hope it is for our client, she will now have to look for an attorney who can fulfill that judgment, right? Who can go and see if there's a collection possible. And I'm going to jump to another story now in this case that we had 5 years ago, where the exact same scenario happened. We ended up with a default judgment. And by the way, these are all huge judgments, over $100,000 in Selma's case, over $200,000 in this other case I'm going to tell you about that was based in protected concerted activity. There were a group of workers at a bakery who came together to assert their rights to overtime pay and minimum wage. And what happened in that case is once we had the judgment, the employer filed for bankruptcy, which is also common, especially for smaller employers. And so we had to wait out that entire proceeding. And by the time our clients got to the point where they found someone to help them enforce the judgment, because unfortunately that's something the clinic does not do, the assets were gone. The employer had gotten rid of or moved around, whatever, all the assets and disappeared. So effectively, they got a piece of paper. They vindicated their rights, which is radical hope for people, but they never saw a penny. And that is a very common story. But now I want to bring you back to a more hopeful, that those stories are depressing. I think they're really depressing. However, I'm going to end on a hopeful note, because by doing this education with clients and with our communities, we actually created a situation of creative lawyering. In fall of 2019, a group of immigrant and migrant workers who had been attending our presentations, many of them had actually been to the clinic and had representation, came to us and they said, you know what? We agree with you. These laws are not good enough. And we agree with you. These processes are not making us whole. We're not getting the money that we're owed. So what we have decided, we don't want to work for anyone anymore because we're going to get exploited no matter what. We want to own our own labor. And we've been doing some research and we want to form worker-owned cooperative structures. And across industries, construction, nursing home aides, cleaners, and we want to be our own bosses. And this is the radical hope lawyering part. I could have said what a lot of lawyers would say, which is, I don't do that. I don't know how to do that. You got to go find someone else to do it. Of course, there is no one else to do it because no one else was doing it in Arizona at the time. But instead, the clinic said, you know what? We're going to be your partner. We're going to figure out how to do this together. And one of the community members and I applied for a fellowship through the Sustainable Economies Law Center in Oakland, California, that does this work, that trains lawyers. The community member was not a lawyer. And I said, no, we need this person also to be here doing this. And it's almost 3 years later, we have now created our first worker-owned entity in Arizona that functions as a cooperative. We used an LLC structure because Arizona doesn't have the great cooperative laws that California has, but that's okay. We figured out how to use the tools of the law to do what our community was asking for. And that requires deep listening, and it requires letting go of the resistances that you will build up in law school to not doing things that aren't familiar. And it requires working alongside the communities that you want to serve. So that is Radical Hope Lawyering. And I hope you all get a chance to engage in it during your legal careers. Thank you.
Good morning. I'm Teresa Woody. I am the litigation director of Kansas Appleseed Center for Law and Justice. And that is a statewide organization, a little bit like the Texas Civil Rights Project. And we partner with all kinds of people. We have 4 main areas that we address. The first is what we call thriving, which is food insecurity and housing. Another is child welfare. Then we have voter engagement. And our Just campaign deals with juvenile and adult criminal justice reform. I also, in my spare time, have worked with the Center for Reproductive Rights for many, many years on reproductive rights issue in Kansas and Missouri. And so I'm going to tell you today, my topic today is state court litigation, protecting civil rights when the federal courts won't. So why state court? One of the reasons is that the federal courts have become far less friendly to civil rights cases. If you, particularly in the areas like reproductive rights, voter suppression, redistricting, gerrymandering, we've seen the Supreme Court either say, oh, we have to stay out of it, or come down with really bad decisions that don't support civil rights. So that's one of the reasons that we started looking to state court. Another reason might be that your circuit court, the Ninth Circuit, usually is a little better. When we're in the 10th Circuit and the 8th Circuit, 10th Circuit's a little better than it used to be. The 8th Circuit's terrible. So if your circuit court is bad, you're going to be up against a block, even if you win at the trial court. If your state constitution can be interpreted more broadly than the U.S. Constitution, and many of them can. They are not identical. They have different language in them, and you can use that language in many instances to bring civil rights cases. And then if you have a judiciary in your state that may be more friendly than the federal judiciary, and we are fortunate in Kansas to have that. We have merit selection for the major counties and cities in Kansas, and merit selection for the Supreme Court. We did have merit selection for the appellate courts, but Governor Brownback, the administration before this one, changed that through the legislature. So now it's a Senate affirmed kind of situation. But they can't do that to the Supreme Court unless they change the Constitution, because the merit system for the Kansas Supreme Court is embedded in the Kansas Constitution. I'm going to go through a quick case study here of reproductive rights, and this is a case that I worked with the Center for Reproductive Rights on and started in 2011. And in 2011, the legislature of Kansas passed what we call TRAP laws, targeted regulations against abortion providers, which basically tried to regulate abortion clinics out of existence. So we challenged that in federal court. First went to the United States District Court for the District of Kansas, and we obtained a temporary injunction on the law and the regulations. But we were thinking about what was going on even then in the 10th Circuit, the sort of resistance we were seeing, the Casey case, things cutting back on reproductive rights in the Supreme Court. And so we filed a companion case, the same case in Kansas State Court, only under the Kansas Constitution, not bringing federal claims in that case, only state claims under the Kansas Constitution. And once we got an injunction in Kansas in the trial court, we dismissed the federal case and proceeded forward on the proceeded forward in state court. In 2015, the state legislature had enacted another statute, and this statute banned dilation and evacuation, which is the most common form of second trimester abortions, would ban that and impose instead some very experimental, shall we say, regulations designed, of course, to make women not be able to have second trimester abortions. That was the entire desire and intent. So we challenged that and we went directly to state court. And we got an injunction in state court. And in that injunction, in that decision, the state court decided for the first time in the history of Kansas that the Kansas Constitution protected the right to abortion. And that was the first time that we had ever had that said by any court. Of course, the defendants appealed that case to the Court of Appeals. And this, we argued the case in the Kansas Court of Appeals. It's a 14-judge Court of Appeals. They decided to go directly to en banc because it was such an important question for the Kansas Constitution. And the vote there, and remember I told you that the way of choosing the judges had changed, so it wasn't just merit selection. The vote there was 7-7, even split among the Court of Appeals judges, which fortunately means that we were affirmed. So the law continued to be enjoined. But of course, there was an appeal to the Kansas Supreme Court. And in 2019, the Kansas Supreme Court held that Section 1 of the Kansas Constitution is broader than the U.S. 14th Amendment and found that Section 1 protects the rights to terminate a pregnancy and holds that the laws that seek to regulate abortion are subject to strict scrutiny, the highest form of scrutiny available for constitutional challenges. That's much better than we could have gotten in the federal court. Even if we had won in the federal court, the strict scrutiny, the standard for evaluating laws that regulated abortion in the federal courts had slipped substantially. And so it was basically sort of a rational basis balancing test. It wasn't strict scrutiny. So that was an amazing win where we had the Kansas Supreme Court say that the Kansas Constitution protected abortion rights for women and other pregnant people, and that it was subject, that any laws attempting to regulate those were subject to strict scrutiny. But of course, the legislature couldn't be happy with that. So in 2021, they decided to put a constitutional amendment on the ballot, the August primary ballot, election pretty generally ignored by lots and lots of people, with the idea that they would get people to come out and they would reverse this decision. The decision was called Hodes and Nausers versus Schmidt, that they were going to get a reversal of that by passing a constitutional amendment that gave the legislature the right to regulate abortion in any way it saw fit, and saying that the Kansas Constitution did not protect the right to abortion. So, so there you go. You're not done yet, right? But fortunately, and one of the things to note here too, we talk about initiatives and how Kansas has no initiatives. The people are not able to get anything on the ballot. Any constitutional amendments have to come from the legislature. So, we have to work with what we have. But in 2022, of course, the Supreme Court overturned Roe v. Wade through the Dobbs case, and said that the states could basically regulate abortion however they would like. And so at that point, we mobilized across the state of Kansas, and all kinds of groups who were pro-choice mobilized. We printed signs. We had all kinds of forums. The League of Women Voters, the Kansas League of Women, we all worked really hard to make sure that the voters understood what was at stake in this August primary ballot. And we had the largest turnout for August for a primary, I think, forever in Kansas. It was huge. It was almost as big as the turnout for the presidential vote. And Kansans by over 60 to 40% rejected that amendment and let HODIs stand. So abortion remains legal in Kansas. Now, and I'm going to give you one other example that just happened recently in voter suppression rights. And the Kansas Appleseed, along with the League of Women Voters and some other organizations, filed a lawsuit to challenge some voter suppression laws that had been enacted by the legislature. And one of those was to ban people from collecting more than 10 ballots, meaning that you couldn't go out and help people collect their ballots and take them to a ballot box or bring them to the election board. The second, one of the other challenges was a signature matching challenge, which is a disaster, because what you have is people who are poll workers, basically election board workers, trying to see if these signatures match. And of course, that's really difficult to do. I mean, if you look at your own signature, if you're in a hurry, it looks really different than if you're very careful. If you're tired or sick, it looks different. It changes over time. Your signature when you're 18 looks nothing like it looks, 50 years later. And so, it's really asking the people, the poll workers and the election board workers to do something they are not really at all trained or capable of doing. And studies show that when you have people trying to match, lay people trying to match signatures, over 24% of the time, almost a quarter of the time, they will kick out legitimate signatures. They will say that they don't match and kick them out. So we challenged that, and in state court, we challenged it in state court again because of the recent election. The recent Supreme Court opinions were not hopeful or helpful. So we challenged it in state court, and we at the trial court we lost. The trial court looked to the federal rules, applied Anderson verdict, said, oh, the state has a rational interest in voter security and avoiding voter fraud, and we lost. So we took it up to the Kansas Court of Appeals, and I'm happy to report that 2 weeks ago, we got a 3-0 opinion from the Kansas Court of Appeals that said voting is a fundamental right under the Kansas Constitution, and regulations of voting are subject to strict scrutiny. So, we're hopeful that our Supreme Court will uphold that, and that will be another fundamental right under the Kansas Constitution. Now, of course, there are some concerns about state court challenges. One of them is funding issues in many instances. In federal court, if you're successful in a 1983 action, for instance, you can get attorney's fees. In many states, and Kansas is one of them, you can't. You can win, you can go all the way up, but but you're not going to get your attorney's fees back. So that means you have to find funding for those cases. And we were fortunate in the reproductive rights cases to partner with the Center for Reproductive Rights, because they have the resources to help us. In the voter cases, we were fortunate to partner with the Elias law firm, which does this work all over the country, and they have the resources. Some of the other times the Kansas Appleseed's been able to apply for funding to get litigation expenses and things like that. There are grantors out there who you can apply to specifically for impact litigation. But it's a difference. Sometimes you have judicial issues in states where judges are elected or not selected through a merit system. The judges may be very concerned about an opinion they have that might be considered unpopular, or they may fear political blowback from their constituents. And that may make it more difficult to have a court that is helpful. And as I was talking to one of you all yesterday, there is some strategy in that, because if you've got bad state courts that are not helpful and you have a blank screen, you can do some damage by bringing cases, because you can actually get bad law enshrined in the state law. Another issue is consistency. Judges are subject to retention votes, even if not election, so they can be removed. Many judges can be removed. If you may remember, many years ago, the Iowa Supreme Court had held way back before the Supreme Court looked at it, had held that that gay marriage was legal under the Constitution in Iowa. And there was a huge campaign when the judges came up for retention to be voted on to be retained. There was a huge campaign. They were kicked out, and the court then rescinded that right. Last year, the makeup of the Iowa Supreme Court had changed. The Iowa Supreme Court had said several years ago that Iowa Constitution protected the right to abortion, and the other court, the newly constituted court, reversed that right. But that's the same thing that could happen in the federal courts as well, as we see in Dobbs. So there's, that's not really a reason not to try. So are state court constitutional challenges worth it? Yes, they are worth it. If you have the right courts, if you have creative ideas, if you have a constitution that you can use to your advantage, or even statutes that you can use to your advantage, they are very, very possible ways of protecting rights in ways that the federal government won't do and is no longer, willing to do in many instances. So I would encourage everybody to look creatively at your state statutes, at your state constitutions. And yes, it's always better to go through advocacy first. It's much nicer to have it, pass through the legislature and be enshrined in law. But if you can't get that done, state courts may be the way for you to challenge some of these laws and protect people's civil rights. And so I encourage you always to take a creative look at that when you're thinking about going to court. Thank you.
Before we take audience questions, I'm just curious if any of the three of you have any comments on each other's. Have you used sort of these cross tools? You sort of did mention it, but I wanted to see if you had any thoughts on that.
Well, I think the workers' rights program is phenomenal. I'm so glad that you're doing that, because you're exactly right. We see so many times where workers are taken advantage of, and I think that's amazing. And we look to the Texas Civil Rights Project, for examples of how to do good things too. And I think we're very similar organizations in a lot of ways, except you're bigger.
Yeah, and I think one comment that you made on just those community partnerships and listening to the community and letting them lead you, it is very counterintuitive, I think, for lawyers. I'm not a lawyer, but I work with a lot of them. But I think some of our best work has come from listening and letting them lead.
And I think related to that, and Leticia talked about this, is this idea of making sure you're employing stories. That is so key, whether you're in court or whether you're doing advocacy, or whether you're just talking to your neighbor about the work that you do. real human stories and the humanity that, again, Secretary Fontes was talking about is what animates the law. And without those stories, it can often fall very flat. And it's really great to have this as a reminder to use state courts is really a good one. And it's unbelievable how often it's overlooked in practice. We're often in federal court because we've got great employment labor laws and that we could be in federal court with. But this is an underused resource. I think state courts, of course, you want to know what state you're in and what courts you're looking at. But yeah, so both of what you said resonated with me quite a bit.
If we can do it in Kansas, you got a good shot anywhere.
Time for one question. Thank you, happening.
During one of my summers, I worked at a plaintiff side labor and employment law firm, and I was just wondering, it really struck me that labor or employment laws is one of those weird things where you can tell the state civil rights commission that there's discrimination going on or this person isn't being sued, and they almost never take on the suit themselves. So it's almost always enforced by private actions or through clinics like yours. I was wondering if you knew the reason why that is, or if it ever could change where municipalities, states, cities actually start to enforce these laws themselves.
Thank you for that question. Did everybody hear that question? And I won't repeat it. Okay. That's such a great question. And it's such a frustrating question. And it's not just on the local level. It's very much on the federal level. I was actually just speaking with one of the heads of our Department of Labor Wage in our offices in Phoenix. I was talking with him on Friday or Thursday, and he was telling me that even though they have this enormous desire to be doing enforcement under this administration, they are so woefully under-resourced. I think it's something like for overtime under the Fair Labor Standards Act, it's something like 0.1% of all businesses ever get investigated because of the sheer resource issue. And on a state and local level, that's even more. Feds have some money on the state and local level. Often it's just multiplied that problem. And so that is, I see it, and maybe Leticia has some thoughts about this. I see it more of as an advocacy issue where we have to put people in our state legislatures who are going to fund our local labor agencies, because otherwise they're completely toothless. Our state labor agency, the Industrial Commission of Arizona, if they get a complaint from a worker and the employer just disagrees or says, oh, that person was actually an independent contractor, which is what they say all the time, the state agency just throws up its hands. They don't even do an investigation. Forget bringing suit. They're not even doing the full investigation. And when the employer doesn't respond and somebody gets a piece of paper, the judgment, they don't enforce those judgments, even though they could, they don't. So people are left with nothing. So again, I think there is reason to hope that we can get our state and local agencies to do more than just be these toothless guardians of the law. But we have to put pressure on them to do that.
Yeah, and I guess this actually reminds me of some of our voting rights work. So we have a lot of, I'll call them friendly counties, but that still slip up when it comes to positive enforcement of the Texas election code. For example, not having enough polling locations. And if we tell them like, hey, you need more, like go add them or we will sue you, they're like, oh, well, okay, now that this is in front of us, if you do sort of all that work for them and present it to a friendly group, they will sometimes do the enforcement. So they won't do the investigation, they won't do all of the other stuff, but if you bring it to them, they'll be like, oh, okay, I'll look into it now. Because it's usually a resource problem.
I'm wondering if you all could tell us about some unlikely partnerships that have been helpful in your advocacy. Bill talks about, okay, it's a David and Goliath kind of story, or how there's no one else in the state that was doing the type of work that you were doing, so you went ahead and learned it so that you can support the communities that you were starting. And you also talked about the Chamber of Commerce actually being someone who was signing on to your letters. Can you speak more about things like that? Have there been partners that you didn't expect would be helpful in your advocacy, but actually played a helping role?
I guess I can speak to that. I think thinking about it, thinking of it strategically, it's about who will the person you're trying to convince listen to. So we didn't go to the business community because, you know, we want a long partnership with them, but we knew that the politicians that we wanted to convince were going to listen to them. When it came to stuff on like the border wall case, it was about showing that it wasn't just this one landowner caring about their land. It was about the entire community opposing a border wall going up in their community. So it's about, the story you want to tell. It's about whose voice will resonate, who will that decision maker listen to, I think.
Yeah, I agree with that. And I think that sometimes that does come from surprising places like, the chambers of commerce on things that can affect business. And one thing that we found in our advocacy, and it's cynical, but it works, is to say, this will save the state money. So if you can come up with a way to posit what you want to do by saying, if we do this, we can show you this will save the state money. That has been one way we have been able to work with a very, very conservative legislature in Kansas.
And don't forget to reach across the aisle to your counterparts on the other side. So we have recently convinced the Industrial Commission of Arizona to have a conversation with the clinic because we see the enormous barriers and challenges our client populations face when trying to just even file a complaint. But the reason why we got that audience is because I reached out to someone in the defense bar, the Defense Employment and Labor Bar, who represents big corporations and actually has worked on some of the FAQs for the Industrial Commission. But he agrees that we need to have accessibility and we need to have transparency at our state labor agency. So I had a number of conversations with him, and then he reached out to the Industrial Commission because he knows people there and put us in touch. So don't forget that we are all one bar, and in the communities that you practice in, everybody knows everyone. The legal world is small. It's certainly true in Arizona. So you want to maintain those relationships, even though you may not always be on the same side of a particular issue.
Thank you. Please join me in giving us a hand. So I need you guys to come down to like bottom 3 rows, if that's okay, sort of smush together. And then the photographer's gonna read a bit more and state the ending. You're welcome. All right, so I need that device. So the center here, we're going to take it just a little off center for this photo here. So, yeah, everyone will all be together now. Let me know if you can come down and fill out the front. And if you take your time, first row, you put up here on the case. Just like your first row. All right, so let's see here. So we need a few more people. So first row, let's have you guys, you come down here. So go ahead and come on down. We're gonna squish in really tight.
Let's see, make sure I can see everybody. Okay.
Can I have you two on the stairs? Yeah, and you, sir, come on down this way. And we'll just have y'all on the end here on that side. This is the quietest group photo I have ever taken. Okay, let's see here. Making sure I can see everybody. I think this is great. Scoot in just a little bit more. Yep, perfect. All right, let's see here. Let's see if I can see everybody. Almost. So let me have you go ahead and head up to the gentleman in the jacket there. And then let's see, can we squish in just a little bit more? There we go. Let's see. Oh, we almost have it. All right, so what we're gonna do to save a little more space is we're gonna have everybody on this side. You're gonna turn into like this. Yeah. And then everybody on this side, you're gonna turn like this. Lovely. Now we got you like face everybody squish together. All right, I'm gonna take a photo just to test to see if I've got everybody. Almost. Might just have to do this. Yeah, let's take him back. There's all your lovely faces. All right, so if I look right into the camera, ready, 1, 2, 3. Perfect, and another ready, 1, 2, 3. Okay, great. I'm just gonna zoom in here, check everybody out. Everyone's eyes are open. That's amazing. So great. We have it. Thank you all so much.
Well, I like I'm going to be I'm like, I got it.